Hi, everyone. Pop-up live. I wasn't expecting to be able to do this for, I don't know, probably till tomorrow. First, you are first. I didn't tell anyone I was coming live. I just kind of was like, I'm going to go live. My Harry went to go get the girls from my mother-in-law's because she had them today so that I could work. And then I worked from 9 to 5:30-ish. I just clocked out a couple minutes ago, and I didn't talk that much at work today because so many people, like, missed their phone calls and, like, nobody it was a very boring, nonchalant day at work. I was like, "I need to talk to somebody." Like, there has been no human interaction, very, very little. Not no, very, very little human interaction today, and so I'm like, "Oh, man." You were actually here before Bitter Tim chatted. I doubt it, Heather Brat. Hi, Red Rock. How are you guys? It's so good to see you guys. So I wanna watch this court for Kouri. She was back in court again. I think it was Friday, actually, to be honest, and I completely missed it. Most of you guys know baby Sleuth turned 3 this weekend. She is getting so old and so big and so ridiculously just grown, and I can't stand it. And so she's just big now. But so I missed court Friday between work and then, of course, the birthday events and parties and things like that, and so I did wanna watch Kouri Richins' court with you guys. She is let's see. So they are freezing her assets now. The judge made that decision during this court process, and they also had made some rulings about her rights to be able to talk to her children or not, her rights to be able to talk to her mom, and different things like that throughout this court process. And so it's going to be very interesting. I do have it sound boosted so that we can watch it with better audio, of course. And let's see. You were just watching oh, yeah, Sugar Beet. Thank you. Hi, Kate. Hi, BC. I know she's baby no more. Red Rock. I told her, I said, "Your mommy's big girl now." And she said, "No, I not big girl. I little girl." I said, "But you're a big 3-year-old." And she said, "No, I'm a little 3-year-old." Meanwhile, she's the same height as Junior. And so, actually, for those of you who didn't see my short, let me see. Let me pull up my short. Actually, I'll just pull up the video. It might be easier that way. But I just went on and I was editing some of the birthday photos of her. I'll pull those up too, just to give them better backgrounds so that I can put them into cute, adorable frames and put them on the walls and things like that. And, she's just she's just too much. We had a good day. We had a good weekend. She's just very kind and humble and sweet, and just every single thing that she got, it was the best thing in the world. Like, no matter what it was that she was given, she just was so happy and pleasant, and I couldn't have asked for a better response from her for anything. And so these were some of the pictures from this weekend. We just kind of put, little backgrounds with them. She was so happy with her birthday hat and her birthday shirt, and her birthday cake was so cute, and it was a really good weekend. It really, really was. So, and now she's big. She's my big girl now. Time for another baby. Gotta get that new husband lined up so we can make that happen. Hey. Kidding. That's a running joke. I always say that I'm gonna wait until the next future ex-husband. So they are. She's adorable. It's not so much the background as it is her adorable face. So anyways, where are we going? Where are we going with the short here? Uh, where's it at? Oh, I read her all of you guys' birthday wishes, those of you who sent them. And I put her and she said thank you. So I'll play that for those of you who didn't see it. Which I don't know. Do I have the audio sharing? I sure don't. There we go.
Happy birthday. Thanks for happy birthday. Thanks for happy
Oh, it's been stuck.
birthday.
It's stuck. Don't keep replaying. It was cute the first time, not 500 times. But so she said, thank you for the happy birthday. So, yeah, she did. She enjoyed all of it. She did so well. So well. It was just a really good weekend. It really was. So, all right, here's court though. For those of you who are coming for court, you're probably like, this is not court. I can't believe this. What's this lady talking about? Who cares about her kid? There's always going to be at least one person in the replay that's like, wasted my life for 5 minutes talking about yourself and your stupid family. We don't care. So I apologize to that person that's watching this. You can go ahead and hit that thumbs up because we're going to move it on. So here we go, guys. I do have closed caption turned on if you need it. I also have it sound boosted. And I am eager to watch this with you guys on 1.25 speed because we are cool like that. Here we go.
I don't think so either, and here's why. If they had formally
Oh, I
charged her,
forgot
she
she
would
talks so
be
fast.
given due process rights as it relates to to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witnessed tampered. This isn't the first time she witnessed tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, not only did she witness tamper, but because she witnessed tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem. And that's the violations of rules 3.4, 3.6, and the UDA standards is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact, it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, if they charged her with it, you're right. But also then have the opportunity to refute that or go through due process rights. By just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witnessed tampered is a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
And they're
pause
tying
there
all
for a
of
minute.
this together.
All of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning, caused the death
Right.
of her spouse. That's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into because, their justification for the request is we're concerned that she's trying to alter their testimony at future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say they have a theory, right? It's in the probable cause statement. It came out in testimony at the detention hearing. You're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through. Okay? The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps the potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, a jury pool is going to say, well, she witnessed tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem. And the rules specifically prohibit the state from commenting on the theory of the case or on alternative theories of the case or on the credibility of witnesses.
And trying to determine where the line between permissible advocacy and permissible communications that would irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm gonna answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars, and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is the potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean.
But it was everywhere long before
It
this.
was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not gonna sit here and say that all of, this wouldn't have happened, or there wouldn't have been news stories, sure. There would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter. And the news stories have run with.
I mean, I have assiduously tried to avoid news coverage of the case
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter narrative that seems to be provided by the defense side of the media.
I think
Why isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she, she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're gonna do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the ABA comments, this was the second part of your question 2 questions ago, regarding, if they think she witnessed tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in that brief. The second problem is that it should have been, our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point. I'm gonna get there. I can only remember so many numbers. Point 1. And what it says is a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard.
Pause there for a minute. In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, you can't get through trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. Incorrect correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that.
And can we just acknowledge
Yeah.
that during trial, the options are so limited, the jury's already in the box, we
Right.
can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases though, that came back on appeal, right? Like it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were embezzlement kickback, side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, it's difficult in cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and in the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean,
to
I'm
a
gonna argue it
trial.
matters because I'll probably move to motion to suppress it, but
Well, sure. So,
Right.
I mean, but, I'm not expressing an opinion one way or the other
Right.
about any kind of motion in that regard. But imagine the letter came in at trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
the problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that that's the problem. The problem is their statements and the way they've interpreted it. And the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems. And those aren't going to go away. Forever, there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue. Yet the dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find jurisdiction that is certainly not the state of Utah that is going to be materially different than Summit County in terms of its saturation of media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for change of venue. Based on I agree. Unless we're going to some tribal land they've gone, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention that we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved, they're going to be subject to whatever ruling I make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting the case, making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why though on a going forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to this region?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and defense theories gotta be allowed because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation and this is where it ended up. And if it's,
Tell me what you mean by that.
well, they made the ultimate conclusion that she's guilty in their briefing.
Okay.
And they were involved with the sheriff's office throughout the entire investigation. And they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forward with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they go look for any. I think the implications of.
That's a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself.
I think
Disqualifying the Summit County Attorney's Office.
I think in order to fix the narrative that the state has put out there, there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged, is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't that
potential.
problematic as well, though? Or are we sending a message? I mean, we'd have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing, essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument. Right,
but it'd be based on evidence.
Fair enough.
Right?
Yeah.
And you could, that is, I mean, that's what we advocate in closing arguments. You can say, you know, we presented this, the jury gets away the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay.
Well,
Mr. Flip.
Good afternoon.
State's briefing is a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazzaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things that we allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing. And the defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in the prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have knowledge of a whole long list of things, including the briefing, media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can't see as very impartial. Summit County Court has said a jury is going to pouch on that. That received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. I can think of two pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see Summit County juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that another state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct trial motion was kind of a drop in the bucket in the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else in the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you.
Please.
So amazing. The first point I'd like to bring up, and we addressed it in our briefing, is that the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, I mean, essentially, what they say is that maybe it doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges,
Right.
I agree with you.
But is it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're gonna focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't.
So the only reason I raise that is to say, in that alternative universe that I'm describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, sees a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that wasn't true.
Well, that's probably
So,
not to
and I don't
too
want
far
to,
in the
yeah, I
direction,
don't
but
think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's in charge?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that the jury is going to make in this case after it hears evidence is that because she witness tampered is a consciousness of guilt. She induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, visible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules. It's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase consciousness of guilt in a number of different ways that doesn't say she's guilty of witness tampering. We're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue, where we're not working, we're limiting our ability to work on other things, we're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. As well, they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative for the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't handle the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe I don't know how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, nobody would see it, right? The jurors, I panel juries all the time that have never heard of my clients and have no clue about anything that happened, and they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, I have jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, obviously we're here asking for dismissal, but alternatively without grave sanctions against the state. And we suggest that they be removed and the start over or continue forward, so I should say, with a clean slate, in order to, put some order back in and, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, the lofty reason a lot of us started doing this in the beginning, because we're going to be a champion for the rules. But, and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice, and a world that thinks that her liars and her witnesses and her counsel, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
Thank you for your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions that no such link exists in the evidence. That defendant concocts a false narrative. That defendant's own handwriting, she attempts to induce her brother to testify falsely. That she is facilitating witness tampering and supporting a false factual narrative. That she is giving her mother instructions to induce her brother to testify falsely. That this may indeed not be the first time the defendant witness tampered. And that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it, parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial. And these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient voir dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied. All right. Any questions, Mrs. Lasagna? Mr. Blunt?
No, yeah.
All right. Let's move on from there. Let's go to the no contact order. The motion for no contact order. Mr. Bloodworth, you probably had this sense when we last discussed this, but I'm disinclined to limit Ms. Richins' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter that kind of work. Second, there are several non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues that are being raised in the civil cases, the estate case and the wrongful death case. And so if I gag her in this criminal case, I'm prejudicing her in those cases. Moreover, the cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded. You have the letter. You're asking for the narrative. I don't understand what the prejudice is here.
Your Honor, let me take a second crack at it. Well, in the course of this explanation, get to the prejudice. Your Honor, in a sense, the court has its hands on the dial. And if it turns the dial in one direction, it can amplify the protection against witness tampering. If it turns the dial.
Assuming any has occurred, right?
I'm talking going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraint. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very narrowly. I think we're at a point now, having all learned a little bit over briefing and argument before today, including based on where we stand now, the state would kind of adjust the dial, accept some risk of future witness tampering in order to more narrowly tailor prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced in your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare. That would allow necessary conduct with her mother and brother to prepare her defense, but it would in place counsel there to ensure that it was just preparing. Then the order would read: all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications text. And I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure going forward there is no witness tampering. And the state thinks restriction on in-person and texting allows monitoring kind of without gaps. We can get into monitoring hours of phone calls. There are gaps.
Status quo right now, a defendant in the Summit County Jail is going to get notification when they make a phone call that it may be recorded.
Yes, Your Honor.
In-person meetings, are they notified that those may be recorded?
Yes, Your Honor. They are audio and visually recorded. The inmate and visitor are both notified.
And the status quo, the inmate can't pass anything to a visitor, correct? Outside of counsel. We'll get into that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
At a lot of time, I've been expecting to say, which is part of housing somebody, I appreciate that.
In prosecuting them, yeah.
And that risk that we're missing.
Okay, I understand your position. Thank you. You'll get the last one.
Listen,
I'm sorry, Ms. Lazaro, is this one yours? Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right, is there anything else you want to say about it?
I think it should be denied, and I think that, I'm just gonna reiterate, the problem is the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well,
I mean,
perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
yeah, if the court wants to.
One of the several plausible ones would be consistent with the state's version.
And one would be the defense's
Agreed.
version, and.
I guess what I'm saying is,
if
why
the
do I
court
have to
wants go
figure it
for-
out?
Well, we don't, and that's the problem, we shouldn't even have to. Like, that's the whole problem with all of this, is they're alleging a crime without any sort of due process or without any sort of evidence to support it. And the fact that that letter,
There's some, that letter exists.
a letter exists, yes, but there's no indication in the reading of that letter that that letter could be written in the lens of, these are the people who are gonna testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inferences made by the state is just because she held up one letter that she must have was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And, I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened as part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Yeah.
Okay. I understand your position. Mr. Blevin, all right. Issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state hasn't. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendants' communications with everyone except her lawyer are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied. Okay, anything further there, Mr. Clifford?
No.
Ms. Lazar. All right, Ms. Lazaro, the motion to enforce order for contempt sanctions, did I sufficiently address that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Until I need a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You claim you assert it's privileged, correct?
I don't, there is a folder or a manila envelope that Ms. Richins kept in her cell.
Right.
That contains a lot of pieces of paper.
Okay.
Okay. As far as whether a document, our assertion, yes, is that everything contained in that is privileged by way of, it was given to me, it wasn't given to anybody else, it wasn't published, it wasn't, nothing else was done with it. So yes, that's our assertion.
So the defense asserts that a 60-page or 60-something page document is privileged. The state asserts it is not and is material to their case because, depending on which version of the explanation you focus on, it reflects a partial factual, partial fictional narrative. Typically, what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the document, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendant's interests on this issue, the review attorney represents the state's interests, and then I make a determination.
We could do that, or the court could do an in-camera review. We, as a team, kind of really discussed this kind of came up last minute, as far as putting it on today. And I guess I'll put this question to the court, part as to how you want to go far enough. Part of our, I think, concern or things we want to address as it relates to privilege is how and where it was found. And if the court is just simply inquiring as to the contents of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient. If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct, it would be, but this isn't a takeout menu. These are her handwritten notes.
I know, but
So,
I don't know what they say. So if they are in fact a fictional narrative where she's just writing a short story, I'm not sure they're privileged at all.
well, I think
But I'm also not sure the materials either.
I was gonna say, I think it needs, before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privileged, and then what and what not may or may not be relevant before it's turned over to the state for review.
I agree. What I am reluctant to do is make that determination in a vacuum without the
I think
benefit of
that's
advocacy by the defense and the state. And so I agree with you though, it's a two-part determination. And the privilege issue is a gate. If I determine that it's privileged communication, it does not get produced no matter how material it is.
Correct.
All right, let me ask the state about this. Mr. Leverett, you see where I'm headed here procedurally. Any objection?
No, Your Honor, that's what the state asked.
It was unclear to me though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it, but what would need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interests, but none of your team and none of your office, nobody else in the executive branch could have access to the document or disclosure of its contents. And
Correct,
so
Your
that
Honor,
made the ruling.
No, I back off a little bit of what you said and say the review attorney is not the state's agent, he's a neutral. He was selected by the defense counsel.
Not in my proposal. My proposal is that review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state too would present advocacy on its behalf, at least to the threshold matter of privilege.
How? You want what's in the document. So you need a lawyer that has access to it. And it can't be
Well,
enough for the litigation.
No, Your Honor, to some degree, the state does know what's in the document because the state has listened to jail calls where the defendant describes in great detail what's in the document. That is
Maybe, but we have no idea if that description is accurate or not. The document speaks for itself.
correct, Your Honor, but how the review attorney interprets the document will depend on some measure in the defendant's characterization of it. So the state,
Fair enough. And so will the defense have to navigate those waters.
yes, Your Honor. The state envisioned and asked for a procedure with the review attorney for the court. We asked for it in the alternative, whereby both the state and defense can present legal argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. And then he can make a threshold determination on privilege. And then once we're past that, there may be a material determination.
It's not the way this usually works. And candidly, we're describing hamstrings on both sides. I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, who for this specific task is walled off from the state's prosecution team? But I represented members of the media, this is how we did it. Right? Like, I can't share any of this information with the reporter, but I can argue why they should have access to it based on the content of the document. Where do you see the error here?
Your Honor, the state's agreeable to pursuing it in the fashion the court described. I've seen it work both ways. I think that what you described is perhaps more common in civil litigation context than in criminal one.
Sure.
And I'm fine to proceed, the state is fine to proceed in either fashion, but the state's, the thrust of the state's argument is material needs to be reviewed by the neutral. The defense alone cannot make a privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, the state agrees.
I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazaro.
Sorry.
You feel like we need
Yeah,
a different direction?
just, I guess, 2 points I'd like to make. Given that the court is viewing the review attorney as an arm of the state, our preference would be that the contents be reviewed in camera, or at least the
Maybe I'm
initial.
wrong about that. Forgive me. The existence of the review attorney,
Generally speaking.
their
I agree with that.
identity was new to me until I read the briefing on this issue, right? And so it doesn't have to be the review attorney, but what I'm trying to avoid is, on the one hand, the court making this determination without the benefit of the adversarial process.
We're not asking for that. I agree with the court's proposition as to how to move forward, and that it first get reviewed for privilege, and then we address materiality of it. I don't think, when we're talking about the first step and the privilege, if we're arguing about whether or not certain things contained in there are privileged or aren't privileged, the council here today should not be able to make those arguments because it negates the whole point of privilege.
That's my point.
Okay.
And so that's why I think they, in my version of the procedure, need to have an outside lawyer whose sole role is to make those arguments on behalf of the state.
And we have identified Mr. Jordan as
That
an agreed upon review attorney.
Okay.
As it relates to that. So I guess I'm envisioning probably 2 separate processes. We have a hearing on, or at least briefing on privilege and then briefing on materiality.
Yeah, maybe we just do all at once.
Well, I guess, yes. Well,
If you're gonna review the documents,
That's
we're
fine.
briefing this.
that's fine. The other thing I just think is an important, like a side note, and this is probably gonna come up in the briefing. The jail searched that packet multiple times and passed on everything in it. It was, and I'm just bringing that up as, and like I said, it'll probably come up in argument, but, they've already, they have been proven. So,
I'm not sure what the significance of that is, but I don't know that I need to.
yeah, we don't need to
right
get
now.
into it today.
Okay. All right, so,
Do you have any questions?
no, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I understand. I'm moving this issue in a direction maybe you didn't anticipate, but are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled off review of the 60 whatever page document? Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe not.
Your Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Right. Okay.
And so my sense is we need a new attorney.
Maybe so.
That I don't want any of his other reviews to
Be effective.
be affected.
Why don't we're going for about 90 minutes. Why don't we take a 15-minute break?
Before we get there, can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to start with.
That would depend upon materiality, right? I think that's right.
I mean, I think the
Hypothetical.
state needs to make a showing as to why they think they get this packet, first
No,
of
no,
all,
no,
right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any emotion like that in front of me.
Okay.
The state knows about it. They know some things that Ms. Richins has said that they think refer to the content of the document. Don't know whether or not they're accurate. We'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right? That's the kind of thing that would need to be, if it's, here is a short story about carriers, I'm not sure it's the kind of thing that needs to be handed over. Do you see the law differently?
Well, I guess in my mind, we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it. And I think it doesn't, before we ever get to any of those steps, like,
Well, I
why?
think they would say they have a sufficient threshold to trigger the privilege review based upon portions of the recordings of Ms. Richins' jail calls in which she says this is part fictional, part factual. Am I summarizing that correctly, Mr. Bloodworth?
Yes, Your Honor.
And so there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened. They're factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress it, I don't know, and then to trigger the related materiality. Do you see it differently?
That's fine.
Why don't we take it?
Yeah.
Okay, sounds good. Listen, there's a lot of people in here, so if you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much.
All rise. Drop these bags in here. Anything else you want to
All rise for this brief break, intermission, and then we're gonna time warp. So here's my thing with this. I really don't think that I agree with the defense in a way that she doesn't need to stop talking to her family. Like, keep burying herself, keep digging that hole, because they're going to use all of that information as evidence in the future, anyways. And so I don't see how it affects anything. Do I really think that her side of the family should have the kids right now, from what I understand? And no, but I don't know. I don't even think they should have access to those kids. That's my opinion, though. There we go, back to court.
I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So I guess what I need from the court today is an order telling me I need to turn over the 60 pages. If that's what the court's inclined to do.
No, I'm inclined to not do that.
Well,
So
am I,
let's take a step back. I understood, Mr. Bloodworth, that we were talking about a document, not the folder.
Your Honor, there's letter number 2,
That's what she held up.
which is the one she held up,
Okay.
and then 60 or so pages of what she describes as the continuation of the walk the dog fictional language.
Okay. Are those the two documents we're talking about?
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or a marked folder to their attorney.
Well, yes, Your Honor, but when removal of the material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two documents. I don't have enough to speculate about what may have been in or not in that folder, and now I understand the significance of Ms. Lazaro telling me jail staff went through the folder several times. Now I understand where you were headed with that. Let's stay focused on just the two documents. The one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
Why shouldn't we handle those two documents in the way the court proposes?
I have no objection to that, provided that the court order me to give them to the review attorney or the court. I have no objection to those two documents.
Well, we're
So
going to
long
put an
as-
order in place first, identify who either the review attorney or the shielded representative of the state in this process is. And listen, I understand that normally the court would just review a document and make a determination about privilege.
I just want to check because you guys are on a delay from me. And so I can't tell if it's back yet or not. Is the audio back or is it still missing? And I'm just gonna wait and go and make sure that it's back.
This case is very high stakes.
Taylor should be talking right now. Let me know if you guys can't hear it.
I don't want to make this decision without the benefit of the adversarial process, so we're going to use belt and suspenders on this one. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody at short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order council to meet, confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document in layer number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Lismer?
Yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order. Can you meet, confer on that within 1 week?
I am, yes,
Or
Is
no?
probably not, actually,
Okay.
I'm gone. I'm gonna be out of town working the majority of next week and I'm on vacation as well.
How much time would you like to get this sorted out?
Can we go to maybe the beginning of December?
By December 1, I need a proposed form of order or competing proposed form of order submitted to the court.
And just so I'm clear today, the court's ordering me to,
Not disclose anything yet
until you have. this
until the
proposal.
rules of this review are set. The participants are identified, those that cannot participate are identified, and that order's in place.
Okay.
Then everybody will know what they can and can't do.
Understood.
I think that's the appropriate way to handle this. Any objection, Mr. Glover?
No,
Okay. All right. That handles for today. The motion for good cause, motion to compel good cause disclosures. To be clear, I'm not expressing any opinion one way or the other about what's in this document, whether it's material beyond the facial, prima facie showing of good cause, or whether any other privilege would apply to it. I just don't know what's in it. I need better briefing regarding the circumstances under which it was created, who was provided to, things like that. Okay. I think, Ms. Lazaro, Mr. Bloodworth, that brings us to conclusion on the motions that are pending in the criminal matter. Is that correct?
Yes.
Okay. Mr. Bloodworth?
yes, Your Honor, to the extent motion to compel is concluded.
Well, it's concluded for
For
today.
today.
All right, very good. Let's turn next to the probate case.
Switch spots. Your Honor, perhaps before that, can we discuss scheduling of this matter? I think that was part of today's initial agenda.
Yes, that makes sense. I can appreciate why you wouldn't be comfortable having this matter not have a next scheduling conference, but there's a lot to be worked out on some document and discovery issues. Ms. Lazaro, what do you propose?
I think my proposal would be, let's get this order in place with the timelines and then schedule dates accordingly at that time.
I'm comfortable with that, Mr. Bloodworth, if you are.
Yes, Your Honor. We want them to get something on the calendar by mid-December.
Well, I think part of the court's order was that in our proposed order, we come up with deadlines and then
For briefing,
For
that'll
briefing.
drive
drive the next hearing.
my consideration, and then there will be a sealed hearing, I imagine, to hear from counsel's argument and you make a ruling.
Okay, Your Honor, then we can perhaps
Yeah.
meet, confer, and propose as part of that.
That would be my preference. Yeah.
Yes, Your Honor.
Like that,
Anything else?
If you don't, please let me go around that. That's it, thank you.
Okay. All right. Very good. The probate, Mr. Hinton. No, not Mr. Hinton. Let's begin with the motion for preliminary relief under the Slater statute case 223-500-019. Can I have counsel for the trustee and the estate make their appearance, please?
Yes, Your Honor. Your Honor. James Tracy and Jake Gorange on behalf of Katie Richins Benson, who is a personal representative of the estate of Eric Richins and is also the trustee of the Eric Richins Trust.
Welcome to all of you, and in counsel for Kouri Richins in this matter, please.
Yes, Your Honor. Austin Nate and Skylar's on behalf of Kouri Richins.
Okay, very good. Mr. Tracy, let me ask you some practical nuts and bolts questions here. You ask for an order enjoining Ms. Richins from dissipating her property and assets, acknowledging that she will have some legitimate expenses that would need to be accounted for.
That's true.
You ask for an order imposing a constructive trust on her assets and requiring execution of a trustee's bond. I have a lot of questions about that. And then appointment of a receiver to manage Kouri's property and assets, pending the determination of the estate's petition to establish disqualifying homicide. Talk to me first about the order enjoining Kouri from dissipating her property and assets. I'm unclear to what extent your three buckets of relief overlap unnecessarily or duplicate each other unnecessarily. The statute says what it says. You're entitled to some injunctive relief to maintain the status quo. Recognizing there's the abstract possibility that you would be able to prove a disqualifying homicide. We do need to make sure, though, that I do not inadvertently prejudice Ms. Richins' ability to provide for her defense. How do you recommend we do this as a practical matter?
As we put forth in our briefing, Your Honor, we don't object to payment of expenses for her defense on three conditions. One is that they're reasonable. Two, that they're approved by the court and or a receiver. And three, that they not come from life insurance proceeds or other assets that were Eric's that she wrongfully took. Now, we don't know that we don't have a clear picture of all of her assets.
Pause there for a minute. Money is fungible. Her assets are X amount of dollars. Whether it comes from life insurance or it comes from encumbering real property or it comes from something else.
I think there's a huge difference. Now, again, I'm just looking at the allegations in the information, also the briefing and the detention hearing and the evidence provided.
Sure.
Looking at those things, it appeared that the state had sufficient evidence to establish that Ms. Kouri Richins was in serious financial trouble, and that she had access to millions of dollars of life insurance on Eric Richins' line. Using those facts, it doesn't seem unreasonable to think that most, if not all, most of, or a substantial portion of liquid assets that she had, cash, could have come from life insurance. We think that the court has broad discretion under the statute to preserve the assets of, it says the killer or the killer's estate. I'll just refer to it as alleged, okay? So we know what we're talking about, that they don't want to upset the defendants on this matter. But it seems unfair to us. The whole point of the statute is that a person not benefit from the acts covered. And
I agree. I
get life insurance and then use it for your defense, it seems that you're doing exactly that. Now,
You're doing exactly that if you use other marital funds that did not come from life insurance. Why is life insurance more worthy of protection than other marital funds?
Well, I don't know that it's coming from other marital assets.
You don't know that it's coming from life insurance.
We suspect. We don't know. What we know, apparently, there's facts that show that she was upside down in many areas, but we don't know what money she had from her real estate business. I don't know. But this is really going to be work that we think is appropriate for a receiver.
How would we structure a receiver's involvement so that with respect to approval of her defense costs, Ms. Richins had a clear route to make sure that the receiver was not impeding her ability to fund her defense?
It's very fact intensive, Your Honor. If the receiver, hypothetically, was put in place and was able to determine that, for example, let's say there was $3 million of life insurance or $2 million, whatever it was, and that all of that was given to her defense counsel for defense. I think, you would have to know what they anticipate the reasonable costs of defense are. Is she
I'm asking
stashing,
more of a
is she
procedural.
stashing money with
Please
defense
don't talk
counsel?
over me.
Oh, I'm sorry.
I'm asking more of a procedural question. What if she disagrees with the receiver's determination of what's reasonable? What's her relief?
Your Honor, we come to Your Honor.
You can imagine how much I don't want to be approved
I
of
just
Ms.
don't
Richins'
know.
defense costs.
I'm not sure how else we do it.
Thank you. All right.
Your Honor, the statute, it contemplates sort of a wide range of options. And by the way, I noted as I'm preparing for this hearing, this section of the statute is just a little over 2 years old. Section 8, which we're dealing with, was put in effective May of 2022. And so under this statute, and it specifically says before the court determines whether there's been a disqualifying homicide, then the court can enter a temporary restraining order, an injunction, or to preserve the property or assets of the alleged killer, or the trustee's bond, or a constructive trust, or any other action, which we think would certainly include a receiver under Rule 66, which is pretty broad as well. Under Rule 66, the court may appoint a receiver in any action in which property is in danger of being lost, removed, damaged, or is insufficient to satisfy a judgment, order, or claim. Now, in this case, Your Honors, we put in our moving papers, and since then, I mean, in the month of September alone, 4 properties were foreclosed on that were either in.
Notices of default were issued. Did foreclosure sales actually occur?
There's been additional notices of default, but in the month of September, 4 properties actually were foreclosed on
Meaning,
that had notices of default and there were trustee sale. So there is property being lost right now. I don't know what efforts, if any, are being made by Kouri Richins to try to preserve those properties. We don't know what equity, if any, were in those properties, but we do think that this is an appropriate case for a receiver. Exactly what the scope of the receiver's responsibilities are and the authority to make determinations as, for example, reasonable defense costs, I think we're going to have to work through that.
talking about the constructive trust, typically, right, constructive trust is a equitable remedy imposed after some transfer has occurred to claw it back or provide a notice flag in the sand, however you want to look at it, to say this is going to be coming back in this direction in the future. How would it work here? In this trustee's bond, the way you talk about it, it would be money posted by Ms. Richins, but you don't want her to have access to any of her money. You can see why I'm confused.
Yeah, well, it is confusing. Typically on a constructive trust, as you mentioned, Your Honor, it's a situation where someone has money that under the circumstances, using equitable principles, the court will order that that person is holding the money in trust for another person. So in this case, the way it would be applied is when you have a killer, an alleged killer, that person's assets would be determined by the court to have been held and are being held for the benefit of the decedent's estate, whatever they are.
And that order gets recorded against each parcel of property titled in the name of Kouri Richins.
If it's property, perhaps you would record the order. If it's other assets, they're just deemed to be held in trust. And then I guess if there's transfers out, then potentially what you have is a breach of fiduciary duty because they were being held in trust.
How is this better than the claims for fraudulent transfer deed or maybe reference? I looked at the complaint. It wasn't clear what it was saying. You were actually bringing claims under the Fraudulent Transfer Act versus other causes of action.
Well, there are claims for avoidable transfer, Your Honor, relating, I think, primarily to real property. But as I read the statute, they are giving a court the ability to establish a constructive trust on any property or assets, not just real property, any assets, to preserve those for potential claim by the decedent's estate. I mean, granted, constructive trusts are a little hard to get our arms around because it's kind of it's imposed by order.
Well, the statute doesn't talk in terms of constructive trust, it talks in terms of trustee's bond, right?
No, it says establish a constructive trust on property. And then you can also require an execution of a trustee's bond. Now, I can tell you how trustee's bond typically work. It wouldn't work in this case. If you have Richins shall not dissipate her remaining assets, that ordering that there's a constructive trust imposed as of the date of Eric Richins' death on all assets, and appointing a receiver to manage her remaining assets.
The terms of that receiver appointment would need to be worked out.
Yes.
And correct me if I'm wrong, I didn't see a proposed appointment order in the briefing, or you haven't worked out those details.
We have not. We would want to get with opposing counsel and see if we can work out an agreement.
All right, let me talk to the chamber counsel.
Thank you, Your Honor. It sounds like you may have some specific questions that might be addressed right at the outset on this.
The difficulty here, stated by the part out loud, is the legislature drafted a statute with policy in mind. So I can't take the position that this is never enforceable. It says may, so it's not required, but I think it would be an abuse of the court's discretion under the word may to take the position that I don't have to do this, I'm not going to. I'd have to make some findings about why it's inappropriate in this case. And contend with the either explicit or implicit policy decision made by the legislative branch that this is the type of thing that should occur in a case involving a potential disqualifying homicide, which this is. How do you recommend the court navigate those waters?
I think it's a fair question, and frankly, some of the questions that the court has, asked today, or some of the questions that we've been asking ourselves, is just the practical implications, or how you practically actually create a situation where this makes sense. I think is extraordinarily difficult. And just to add to what's already been discussed, I mean, if we're talking about a receiver over all the assets, I think that would necessarily also include, or typically does within a receivership, causes of action that are held or pursued, which would mean
You can carve those out.
Right, so I guess if that's a way to carve that out, and then to the extent that there's a recovery in those cases, does that also automatically become part of the receivership estate? And all this to say, I think that this will expand the scope of litigation substantially. I think that you will be, the court will be substantially more involved in this than perhaps what it would like to be, or what is necessary, or really what is prudent for judicial efficiency purposes.
Right, but come back down to the specifics.
Yeah.
My biggest concern is inadvertently prejudicing Ms. Richins' financial ability to fund her defense. That implicates constitutional concerns that seem paramount. Is there a way to sufficiently fund her defense, but otherwise prevent dissipation, maintain the status quo, protect assets?
We don't believe so, Your Honor. And
But why?
I guess perhaps there could be a way to craft that, but again, we're talking about substantial amounts of time, energy, and expense to actually figure out what that's going to look like. And so that in and of itself, going through that process of figuring out how we're going to fund her defense, we're going to deplete resources that would have been allocated to the defense in the first place. Does that make sense?
Sort of. I mean, can we agree that I'm not going to ask you what her assets are, and I don't think it would be appropriate for me to put you on the spot about her right now, but do you know what her assets are?
Generally, I would say yes. Specifically, I would say no.
I have no idea how the legislature expected a judge to make this decision without asking all kinds of questions that I really don't want to ask.
And I think just to add to that, Your Honor, particularly in a case that is as much publicity as this case has. If we get into the injunctive relief, and this isn't the briefing, that sort of thing, right? Whether that requires some sort of a finding of substantial likelihood.
Yeah, pause there for a second.
Yeah.
Isn't the easy button on that just to say, as a matter of law, this court rules that the substantial evidence determination is sufficient to satisfy Rule 65A(e)(1), and just stop talking about it?
I mean, certainly the court could do that. I think those are two different standards, and I think we would take the position that for a preliminary injunction, that may well be a higher standard. We obviously haven't come into that a great deal in the briefing, but from our perspective, we think it is a higher standard, and obviously the substantial evidence, at the pretrial hearing, probable cause still hasn't been shown, and I'm not trying to equate probable cause with what substantial likelihood of success in marriage looks like. But
Or
perhaps there's
substantial evidence. Yeah.
or substantial evidence. So it is convoluted, and it does make it a little bit tricky, particularly taking into those considerations as well.
Would you acknowledge, though, that in general terms, this kind of case is the kind of case that is targeted by this statutory provision? That is, a situation in which, if a defendant is found guilty beyond reasonable doubt, or in a civil matter by preponderance of the evidence for disqualifying homicide, loses any interest in all of those assets?
Yes.
Okay. Talk to me about a receiver. I'm not sure that's better.
You're not sure that a receiver is better?
Right.
And I agree. I think based on the discussion that you have with Mr. Tracy, The practicalities of that is going to be very, very difficult to iron out, and what that looks like. Some of the additional practicalities that I've suggested here, and I think as well too. I mean, they've moved under Rule 66, but there's the Utah Commercial Real Estate Receivership Act, which comes into play when we have real property addition to receivership, and so that has obviously not been addressed, and I think would be implicated under these circumstances, so would need to be consulted and addressed as well. So, again, practically speaking, the receiver makes little sense. I think it makes the process significantly more cumbersome than what it already is, and so don't think that appointment of a receiver would make much sense at all in these circumstances.
Has the estate served Ms. Richins with any written discovery asking her to identify her assets?
In the context of the probate case, I do not believe so.
In context of any other case?
I don't think so. And I could be wrong. There's several cases, obviously, and lots of written discovery, but I do not believe so.
All right. Okay, let me ask Mr. Tracy some more questions.
Thank you, Your Honor.
Mr. Tracy, what's the irreparable harm here? There are other tools available to the estate to identify assets in the flow of money, to trace the flow of money, to provide notice to potential bona fide purchasers or other transferees, and to claw back assets. Money in many ways is fungible. Why is there irreparable harm here? If I don't put any injunction in place, but allow you to start figuring out through the discovery process the answers to the questions you don't currently know the answer to.
Well, first of all, Your Honor, typically in civil litigation, we're not allowed to inquire as to a defendant's assets without a judgment. In this case, because
This is a little different.
I know it is, but I guarantee in some of the, like for example, the civil fraud case, they're not going to answer questions about what her current assets are. In fact, they moved to stay in case, which you'll hear here in a minute from my partner, Mr. Kouri.
Right.
Let's talk for a second about, and by the way, in the estate case, we did demand an inventory. As part of the inventory, we asked for disclosure, but we haven't gotten a disclosure, but something we can follow up with motions in the estate case. But I do want to be clear, and I think you asked a question about Rule 65. As we put in our briefing, it's not clear that Rule 65 applies to paragraph 8A, 75-803, sub 8, paragraph A. It certainly does on paragraph B, but that only applies if you're seeking an injunction without notice or an opportunity to be heard. We don't concede that Rule 65 applies. And in fact, in preparing for this hearing, I'm more convinced that it doesn't, and we can submit briefing on that. I think the legislative history will show that Rule 65 was inserted only if you want a injunction without notice or an opportunity of a hearing. Under subsection 8A, no mention of Rule 65 is made. I don't think that we're subject to the substantial likelihood of prevailing on the merits. But we addressed it in our motion in this way. Even if we were subject to it, we meet the requirement. And to that, I would, in addition to your rulings in the criminal case, we had 45 facts set forth cited by evidence, and they didn't dispute it. They relied on her Fifth Amendment right, which she has the right to do, but in a civil matter, it comes along with an adverse inference.
Sometimes the law, that's a little more complicated than you let.
Well, she didn't rebut any of the facts. I don't think we really have a problem meeting the standard under Rule 65, but I don't think it applies technically.
This is why I'm asking you about irreparable harm. Why is injunctive relief necessary here? What about the status quo can't be either compensated in the future in money damages, preserved through other means, better characterized? I mean, just because I don't grant the motion today doesn't mean I can't grant the relief.
So, first of all, I don't concede that you can't get an injunction only when your damages can be compensated through money damages, because there are circumstances where you just will you'll never recover the money. And I will mention, what if there's nothing in 75-803 that carves out an exception for attorney's fees, by the way. And in every case where you have a disqualifying homicide, you're probably going to have a murder trial. I mean, more likely than not. So I don't know that the legislature was concerned about how do we carve out defense costs. When we prepared our motion,
Constitution might be concerned. I said the Constitution might be concerned.
which is why in our motion, we specifically stated we're not seeking to prohibit her from having reasonable defense costs. I just make a note for the record, there's nothing in the statute that carves that out. Again, you have a variety of things in the quiver here that you can use to address this. Just imposing a constructive trust. Seems contemplated,
Why
and I
not,
can't see why not to do it.
why not freeze? With enter an order freezing her assets in their current state of title, meaning can't hypothecate any of the assets out of current states of title. If they're titled in the name of Kouri Richins, they stay that way until further order of the court. If they're titled in the name of,
Richins Realty.
I think I can reach that entity since it's a single member LLC.
We think so.
She'd be a human being that would be acting on his behalf. So if they're titled in the name of KAR, they stay that way. If there are funds in a bank account, they stay in the bank account. Then press pause and let you all get better information about why you think this will or won't work. You're asking me to shoot in the dark here.
Because we are dark.
I know, but if you serve some discovery, we'd all be better off. And now there may be reasons that hasn't happened yet, but I'm just saying there are tools available. What do we do about the fact that our properties or properties titled named KRR have notices of default?
Well, it's gonna take an analysis of whether there's enough equity in there to bother trying to rescue them. But I think
Presumably, Ms. Richins has an equal financial incentive to do that, right?
depending on the amount of equity in it.
Sure.
If it's only $20,000 of equity, maybe not. With regard to your suggestion, Your Honor, we would welcome and certainly we would welcome and take from the court a freeze of the current assets. I think in addition to that, I would ask the court under 75-2803 order that the constructive trust on any property or assets of Kouri Richins was effective from the time of Eric Richins' death. What that means exactly, I don't know. But
Still,
I'm just telling you, I mean, it should be a constructive trust. What that means as far as the consequences of that, I don't know until we know what she did with the assets.
I'm not opposed to that concept in terms of at least casting a hand that goes back in time. How would I structure that constructive trust to have an exception for assets that have been used or would reasonably be used to defend yourself?
Here's what I think one way this might work. The court's order could say freezing all of the assets, as you just mentioned, as of today and going forward. Now, in addition, the court, pursuant to this section, orders that a constructive trust, or that all property or assets of Kouri Richins is subject to a constructive trust in favor of Eric Richins' estate from the time of Eric Richins' death. Period. I mean, it's up to us to decide what we do with that. And here's what I would say. If then, after we find out more about what she's done with her assets, if she made what we think is an unreasonably large transfer, far beyond maybe what was needed for reasonable defense costs, then we would argue that that was a breach of our fiduciary duty. They would argue it's not, and they would tell us why it's not. I don't know how that would turn out. But I think under the statute, it's fair to say, I mean, if in fact she's guilty, we don't know if she'll be found guilty or not. But if someone's found guilty of a murder, it's certainly not unreasonable that any of their assets from the time of the death of the victim forward were held in constructive trust for his or her estate. That seems pretty reasonable.
And so the parties would have their respective arguments about whether expenditures since Eric's death to now were within or outside a proper exercise of Ms. Richins' fiduciary duty.
Yes.
All right.
That's what I think.
Okay. Thank you. Let me ask Mr. some questions. So Mr. Nate, let's focus on those two things.
Yeah.
In order, freezing the assets as they stand today, no hypothecation of anything in the transfers for or without value, and establishment of constructive trust with the parties reserving their arguments about whether any distributions, use, transfers of assets to date were equitable, appropriate within a fiduciary duty outside of it. You wouldn't be waiving any arguments in the future to say, Judge, this is too restricted, you gotta loosen it up so that she can defend herself. It would maintain the status quo, it would honor at least some of the intent of the statute, it would protect the estate of Eric Richins. How as specific as I can be, given what I know right now. What's your response to that?
I think first and foremost, obviously, our position is that no relief should be granted and that the court has, discretion under the statute and should deny the motion. To the extent the court is inclined to do anything with respect to this motion, I think the relief that you just laid out is probably, would probably work and would probably be fine.
At least for now.
For now, for present purposes, yes.
Okay. All right, I appreciate that. Anything else on this?
No, Your Honor.
Mr. Tracy, you're entitled to the last word. Is there anything else?
Just, Your Honor, I think that in an order that you might issue, you should make clear that we're allowed to proceed with discovery on our assets. But again, I know you've got a motion to stay that you're going to hear, and that can be the decision on that as well, I suppose. Thank you.
All right. All right, the issue before the court is the motion brought by the estate of Eric Richins for preliminary relief under Utah Code 75-2803, subsection 8A. The estate requests an order enjoining Kouri from dissipating her property and assets, while also acknowledging that Kouri Richins will have legitimate expenses, such as the cost of her legal defense in the criminal matter. The estate also asked for an order imposing a constructive trust on Kouri's assets and requiring execution of a trustee's bond. And the estate asked for appointment of a receiver to manage Kouri's property and assets pending a determination of the estate's petition to establish disqualifying homicide. The motion is granted in part and denied in part as follows. First, to the extent that the four factors under Rule 65A(e) must be met before the court may impose injunctive relief under 75-803, subsection 8A. The court finds they are met in this case for the following reasons. With respect to factor E1, the court finds that factor is satisfied as a matter of law by the court's determination that there is substantial evidence supporting the aggravated murder charge in this case. Regarding factor E2, the court acknowledges that the difficulty of recreating, chasing, and reversing any flow of funds or dissipation of assets that might occur during the pretrial period in the criminal matter poses an irreparable challenge to the estate in terms of maintaining Kouri Richins' assets for distribution to other parties in the event she is found to have committed a disqualifying homicide. Court determines under factor E3 that the threatened injury to the estate outweighs the damage to Kouri Richins that a carefully tailored injunction would pose. And under factor E4, an injunction is not adverse to the public interest and in fact is consistent with the public policy put in place by the legislative branch when it passed section 75-803, subsection 8A. Having determined that some form of injunctive relief is appropriate, the court is nonetheless concerned that an overbroad injunction will be constitutionally infirm because it will unduly burden Ms. Richins' ability to fund her criminal defense. And to avoid that prejudice to Ms. Richins, the court determines that a limited injunction in the following form is important and appropriate. First, the court is hereby issuing a preliminary injunction that hereby enjoins Kouri Darden Richins from transferring, changing the title of, or otherwise hypothecating any asset that she currently holds or controls, or that her realty company, KRR, currently holds or controls. Second, under subsection 8A, 3, the court hereby establishes a constructive trust on all property and assets of Kouri Darden Richins and KRR Realty. The constructive trust is effective from the date of Eric Richins' death. court will consider in the future as necessary arguments that transfers or disbursements of Ms. Richins' assets to date or in the future are reasonable and necessary to fund her criminal defense. The court recognizes that exceptions to its order enjoining any transfers or changes in her current asset titling or holding may be necessary for that purpose, and exceptions to constructive trust may be necessary for that purpose as well. The court is not imposing the requirement of a trustee's bond. It is not appointing a receiver at this time. The court denies those requests without prejudice. Mr. Tracy, I need you to take what I said and make it look good on paper. I need you to run it by Mr. Nate for his objection or approval.
We will do that.
Okay. Mr. Nate, any questions?
No, Your Honor.
Mr. Tracy, any questions?
No, Your Honor.
All right. That brings us to related motions to stay the probate case and the wrongful death case pending the outcome of the criminal case. That briefing has taken some twists and turns. Mr. Tracy, Mr. Goring, pardon me, I'm doing this in the wrong order. Mr. Nate, Ms. Lazaro, what is the scope of the stay you're currently requesting in those two civil cases?
So again, just to be clear, with all the cases that are going on, we're talking about the probate case and the trust case, correct?
I may be using different vernacular than
Okay.
you. I apologize. So what I have been calling the wrongful death case is 262.
Okay.
And then the probate case, I think, is 019, the estate case, right?
Correct.
Okay.
So with respect to the wrongful death case, and do you want me to come up to the?
Wherever you're
Yeah, I'll go ahead and come up there. So with respect to the wrongful death case, there are some preliminary discussions with what a stay might look like. The plaintiffs in that case, or the plaintiff in that case, the estate, has agreed that some form of a stay is, that they don't object to it. But we haven't really been able to reach an agreement on that. And from our perspective, we think the overlap with the wrongful death case and the criminal case are so substantial that we maintain a position that a complete stay on that case is necessary and what we're asking for.
So pause there for a
Yes.
second. I don't know if this is accurate, but I think it is. Imagine, though, for the purposes of the hypothetical, that the wrongful death case ending 262 includes some will transfer causes of action. Why shouldn't they be able to go out and try and claw back some assets, get them back into Kouri's estate? They would need, maybe they wouldn't need testimony or admissions from Kouri to do it, but if they asked for it, you would have your right to object based on business grounds or others. Well, why would I state that?
So I think, to make sure I'm understanding the question right, is the idea here that perhaps you stay some claims and allow some claims to move forward, correct?
Right. There's a lot of claims. I mean, this gets missed.
Right. Correct. And I think just from an overall or an overarching purpose, as we've stated in our pleadings, piecemeal litigation associated with pursuing some claims, not pursuing other claims, I think undermines judicial efficiency. I think it's unclear at this point. Do I think that there's some potential that voidable transfer claims could be implicated somehow in the criminal trial? I think it's possible. I don't have specifics on that right now, but you add that to the already very substantial allegations that are overlapping between the two cases. And I mean, we think that certainly would lend itself to staying the case in its entirety. And again, to allow the whole case to move forward at once or to stay the whole case in its entirety. And I think that, supports judicial efficiency. It also avoids unnecessary duplication of work, as set forth in some of the cases that were cited in our briefings.
What about the 019 case, the in re estate of Eric Richins? Why would we say that?
So, and again, just the verbiage that we've used on that is either the estate case or the probate case, to make sure we're talking about the same one.
Yeah.
So, we filed a motion stay in that case. You'll note from our briefing, though, on I think it's in the reply in the 262 case, I don't think, and we take a position in the papers, I'm not sure that Kouri has the ability to stay collectively the administration of the state, right? I mean, and that's why we point that out. And so our motion to stay in the context of that case was narrowly tailored to, one, prevent your, staying, any action with respect to the petition to determine disqualifying homicide, which for obvious reasons, right? And then any other aspects of that case that would, require the active performance of Kouri or anything that would require active performance in some aspect of the administration. So I don't think that case should be stated in its entirety. We have taken that position. And hopefully we've made that clear through our briefing that it should be narrowly tailored to, the aspects of the state administration that implicate Kouri, including the petition for disqualifying homicide.
Do acknowledge that proportional discovery in the estate case might include identification of Kouri's assets, where they are, where they went.
Particularly in light of the court's ruling today, yes.
Okay. All right, that's helpful. I appreciate that. Thank you.
Perfect. And then I guess I will just add as well, we have the original case that was filed that ends in, I think, 7-6. That one,
There's no briefing in front of me on that case right now, is there?
so there's still a motion to stay that's pending in that one as well.
I apologize. Okay.
So I'm happy to discuss today. If you would prefer to defer, that's, fine.
Give you guys a second to turn down your earbuds before I ear blast you. All right. So, my thoughts on all of this. I'm curious what you guys' thoughts on all of this is, to be completely honest. I think it's very telling, the lawyer's facial expressions, honestly, especially for the assets. Let's take a look at this article that came out. Let's see. Your husband is singing a Christmas tree. You're working on your Christmas tree? Ah, that's so fun. I wish that my husband would let me put up our decorations. Every year I tell him that the snowstorm is coming. It's going to ice soon. We need to put out the outside decorations before it freeze rains. And every year he argues with me, and every year it takes all of the holiday spirit out of the entire season, because Christmas is my favorite. And so every year it turns out to be a thing where since we got together, I barely even decorate anymore, because he wants to wait so last minute to do everything that it sucks the joy out of it for me. So that's a whole thing. But we used to always spend Thanksgiving Day, after we would all eat until we were ready to die. We would spend Thanksgiving Day decorating the tree and the inside stuff, and then all the outside stuff was usually done prior to that. But yeah, it's okay. My next husband will decorate earlier. So is her lawyer's gonna quit now? I don't know. I mean, oh my goodness. I don't know. They were all gulping pretty big though, because what it comes down to is she can't sell anything off now without it going through a whole channel of things. And before this, they had unlimited access to all of these different homes and things like that, that were part of the trust and part of the estate and all of this stuff. And so now they're limited. It's basically froze. So it says court freezes Kouri Richins' assets ahead of murder trial. So the so-called Slayer statute is a law to keep killers from profiting off their crimes, and if Kouri is convicted, it may apply to her. She's innocent until proven guilty, but a court can still take measures to preserve assets in case of a conviction. At a hearing on November 3rd, the 3rd District Court Judge Richard found that there was a substantial evidence supporting aggravated murder charge, so he is freezing her assets for now. So substantial evidence that she is part of this aggravated murder. Shocking. I know. I will wait for you guys to all stop and catch your breath, because I know none of us were expecting that outcome. And let's see. So he freezes her assets. The assets are included by Kouri Richins Realty, where she is the sole employee. He also gives Eric's family a formal and financial interest in Kouri's own estate since the time of Eric's death. So any type of money or financial gain that she has had at all, period, since Eric passed away, since he was murdered. It's collateral in case she transfers money or assets that the court later determines should have belonged to Eric's family. It is likely Kouri will be allowed to transfer assets to pay her lawyers, though. And it says he wants to be careful to preserve Kouri's ability to fund her defense. Otherwise, her Sixth Amendment rights may be violated. Eric's family had also asked the judge to appoint a third party to control money since she earns through her company, Kouri Richins Realty. Eric's family attorney, James Tracy, said the bank foreclosed on 4 of her properties in September of 2023 alone. He refused to divert the potential proceeds from those foreclosures. He again cites that they need to allow Kouri to pay legal fees. She is involved in numerous civil lawsuits besides the criminal murder case. This includes the probate case, which will determine who inherits Eric's estate. There's also a $13 million lawsuit from Eric's family, which seeks wrongful death damages. The court puts portions of the probate and wrongful death cases that overlap with the criminal case on pause indefinitely. The $13 million wrongful death suit had added Kouri's mother and brother as defendants. After Kouri transferred ownership of her mom's house from Kouri Richins Realty back to her mom, that portion of the lawsuit where Eric's family is alleging Kouri is trying to hide that asset from them will still move forward. She also sued her husband's estate trust, seeking the property held by both. They didn't rule on those 2 suits on November 3rd. He told both sides to confer and get back with him with a joint decision on whether those should proceed along the criminal case. Hi, Cray Cray. Yeah. Karma just pulled up, right? She needs to have all the assets frozen because she was in debt and took money from her husband. She was like, we aren't saying in debt as in like, oh man, she's got a couple credit cards that are past due and she's getting behind on things or paycheck to pay. No, she was in debt. Like we are talking millions of dollars. Not to mention all the crap that she had done shystily with her actual realty business. So this is another article that came out shortly after the court hearings. And this one says it says the truth is on her side. I'm pretty sure it's supposed to be on her side, but it says brother speaks after judge denies motion to dismiss murder case. I don't know if he actually talks. See, no, it's just let me see.
And then writing a children's book about grief. Meanwhile, the state is asking the judge to stop Richins from speaking to members of her family. Prosecutors claim a letter was found in her jail cell showing Richins trying to coach her brother on what to say in court. Richins' lawyers argued that the state's public filing violates the rules by making statements about Kouri Richins' guilt, adding that statements from the government hold more weight.
The state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case or on alternative theories of the case or on the credibility of witnesses.
The judge also denied the state's motion for a no contact order. Before today's hearing, the Richins family spoke with ABC News in an exclusive interview.
I do not believe in my heart Kouri could ever not just kill Eric, but kill anything or anyone.
She loves her boys way too much to take their father away from them.
Of course, ABC4 News will be at Richins' court hearing today at 1:30. As we mentioned, we have just covered that, and we will bring you the latest developments on this story.
Yeah, I feel for the children too. I mean, and that's the thing. So they're seeing her, let's see, not seeing her. They're communicating with her 30 minutes twice a week is what she gets to see them. And I'm going to tell you, this has got to be so confusing for these kids because their dad died. Their mom wrote a book to help them deal with their grief. Their dad's side of the family was basically cut off while she was telling the kids that they were against her and how wrong the family was and how bad they were. And now these kids are with her family, trying to process all of these emotions, and she is still talking to them, 30 minutes twice a week. They're probably struggling to figure out, who's honest, who's right, who's wrong, and all of the different things. Plus, they lost both of their parents now. It's a lot to deal with. It is a lot to deal with. Yeah, to go as far as to write a book about grief for your kids, and then it comes to this. I hope they're doing okay and have the support they need. I agree. I mean, it's a lot. It's gotta be a roller coaster. And I mean, and these weren't like, we're not talking about teenagers or late teenagers or anything like that. These children were on the younger side whenever this was going on, initially. They're losing their dad at their prime years. So, I don't know. I don't know. It's a lot. I know, me too. Me too. I feel horrible for the innocent children. I do. I wish that this would go to court so much faster than what it is. And unfortunately, we are we're a long ways out from any decision getting made, any actual court hearing. Now as far as sorry, just gonna yawn for a minute. As far as the um what do you guys think about the fact that the judge is allowing her to still communicate openly with her family? I'm curious on you guys' thoughts on that. Because my thing is, like, sorry, I just had to respond to that. My thing is, there is, mm, sorry. As I was saying earlier, like, they just need to keep handing her the shovel and letting her talk. And I understand why the prosecutor is worried, because what if she actually does sway their testimony, with them getting this information, are we going to be in a situation where they don't give truthful testimonies? I think though that the family's going to try to rely regardless. I mean, they know what she is accused of, and they're not going to want to help get her sentenced. So, I think they're going to try to help her get off any way they can. I hope that the prosecution isn't going to I hope the prosecution isn't going to rely on their testimony, right? Because that would be a mistake. You say, "Let her keep talking." Yeah, true. You think it's bad but constitutional since they couldn't prove tampering. Exactly. How old were the children when it happened? Not entirely. Let me check. I'm not entirely sure of their exact ages. I mean, they're young enough that I would say 10 and under whenever everything happened. 10 is older, honestly, than probably the reality. Trying to find ages. I mean, I don't have ages, but here's a picture of her and the kids and him. I mean, they are young. They blur the faces, but you can see, like, they're not big kids. So, they have to lie. If she loses, yeah, they lose their homes, they lose everything. Yeah, I agree. I agree. But, all right, guys, I'm gonna get off here. I work in an hour. Ugh. I worked from 9 to 5, 9 to 5:30, and then I work from 9 till midnight today. So this is my long day. Locumi will be live in 1 hour, so go check out the Locumi Life. Tonight, she is talking about, I don't know, somebody missing. Let me see, it's Missing Monday, so I know that she is talking about somebody missing. Let's see, who is it? Witness in capital murder case goes missing. Dun dun dun. So that's at 9 o'clock. So go check it out with me. Then I'll be listening in between calls. Here it is. And I'm going to go relax for a little bit before I have to go back to work. Love you guys. Have a good day. Bye.